Great. Well, hello and welcome back to another edition of the Michigan Journal of International Law podcast. I'm Ryan Shaw, a recently graduated law student here and the former managing articles editor of the journal. I'm so excited today to be joined by one of my former professors, Julian Arato of the University of Michigan Law School. Professor Arato is a widely published scholar of international trade and investment law and maybe more importantly, a two-time professor of mine, once as a 1L in international law, and once in the fall semester of this past year in international trade law. His article, recently published in MJIL, is a comparative look at exceptions clauses in trade and investment law, titled The Institutions of Exceptions, Justification in Trade and Investment Treaties. Professor Julian Arato, welcome to the MJIL podcast.
Great. Well, really happy to be here. And now I have a microphone so we can actually do this properly.
Wonderful. We'll start with just a couple questions about you and your own career, and then move in a little bit more into the article that was just published in MJIL. So I'm curious just to know how you became interested in international law in academia, and kind of what your early career trajectory was like to lead you into scholarship.
Yeah, so everyone has a completely unique story about how they ended up in legal academia. For me, I knew I wanted to be a scholar for a long time, since at least the beginning of college. I knew, getting into college and getting really into my great books course, I realized this is what I want to do. I love this, and I did everything I could to go in that direction throughout college. I did a master's in intellectual history and political thought, and I sort of hovered around legal questions for a long time, and everything I was doing was kind of quasi-international, I guess, because at the time the Iraq War was at its height, and that's just the kind of thing I was thinking about, the kind of thing everyone was thinking about. Especially as a New Yorker following September 11th, the Iraq War, the world was, in a great moment of flux, and that was just there. But I wasn't really thinking about international law. I realized at a certain point to work on legal questions, I needed to go to law school. Otherwise, it was just kind of silly. Went to law school, had initially thought I was going to go into constitutional law. I wanted to be an academic in constitutional law, constitutional theory. And frankly, I just had an incredible international law class as a 1L. It was,
As did I.
hear that, folks? And it just changed the trajectory of my whole life. I realized this was the way that I could think about the questions on the inside and the outside of the law. Because in international law, you're always forced, always called upon to defend the question of whether this is law at all, which requires thinking about what is law. So it blends question of jurisprudence, questions of history, questions of policy, all in the context when the profession is globalizing and the problems of the day are global. And it was a thrill, frankly. And from that kind of point, I shifted my emphasis towards thinking about pursuing a career as an international legal academic, basically as of my 1L year. And from the rest is kind of history. I practiced a bit in international arbitration, but writing on the side, and I'd worked a lot on the law of treaties since my time as an intern at the ILC, and eventually found my way towards a kind of scholarly expertise in areas of public international law generally, international investment law, trade more specifically, and that's where I am now. Yeah.
Could you talk a little bit about, so your specialty is being in trade and investment law? Could you talk about the delineation between, what is the difference between those two for someone who's not familiar with trade and investment law? And then maybe the second part of the question, could you talk a little bit about how the study of and the practice maybe of those areas has changed over the past decade or so since
Yeah.
you've been writing and researching it?
Yeah. So for the uninitiated, you can think of international law as having a bunch of different buckets. There's what's called public international law, which covers kind of almost everything anyone thinks of as international law. It covers law of war and peace, trade, investment, law of the sea, human rights. All of that is public international law in the sense that it is legal regimes established by treaties between sovereign states. There are other actors involved, but that's the main thing. Treaties and custom and other sources of international law, but all law primarily between states for governing their affairs in the first instance. There's something called private international law, which is more about conflict of laws for private parties to resolve their disputes across borders. And that's not what I do. That's a whole area of specialization. It's a separate thing. Now, in public international law, of course, there's regimes of law that deal with what are often associated with private interests, especially international economic law, areas of international law that govern not just how states interact, but create incentive structures for the doing of business across borders. And the major two regimes are trade and investment law. There's some international law related to finance, but not much. There's some international law related to sovereign debt, but not too much. The two really thick areas are trade and investment. And what's the main difference between those things? Trade is legal rules that states commit to in order to incentivize the doing of business across borders, buying and selling of goods, the exchange of services across borders. But it's mostly about, being a little bit artificial here, the conduct of business crossing the border. Investment concerns the situation where a foreigner actually sets up a business in some way inside another jurisdiction. And these two areas of economic practice have very different kinds of concerns, where the state, in order to really commit to liberalizing their markets, has to take on different kinds of guarantees, has to adopt different kind of guarantees. So for trade, classically with trade of goods, it's a matter of guaranteeing that I won't interfere with your good once it enters the stream of commerce. I won't discriminate against foreign goods. I will reduce tariffs to a certain agreed upon extent, those kinds of things. So it's about not erecting barriers to the penetration of the market by a good or a service coming from abroad. There's a little bit of overlap with investment, but primarily investment is about what the state owes the foreigner once they are in their territory engaging in business. And as you can imagine, the holdup problems are completely different. If an investor invests $500 million in developing a gold mine in another country, once they're off the ground, uh, they're at the mercy of the state, right? So there needs to be different kinds of rules, different kinds of institutions, arguably, to govern those sorts of affairs. So the practice of trade law, the practice of investment law, there is some practice that's transactional, structuring corporate value chains and supply chains and things like that. But primarily, the practice is a disputes-oriented practice. In trade law, this happened through primarily a single regime, the WTO. There are some other treaties out there, but the real nexus point for international trade litigation happened at the WTO, at least at the international plane. There was plenty of trade disputes that happened at domestic courts, but the sort of big ticket item was dispute resolution in the WTO dispute resolution system. Investment, by contrast, dispute resolution is something that occurs through quasi-public-private arbitration. They're private arbitrations in the sense that a private investor has a right to sue a state, and counsel can help them do that. So many major law firms help with that. And once the suit is brought, it gets heard by an international tribunal, often under the auspices of the World Bank, International Center for International Investment Disputes, or there are other kinds of arbitral bodies that do this. The hearings aren't public in that sense, and it's not state-to-state dispute resolution, so it's not public in that sense. But when the award is rendered, they often are published. So there's a kind of jurisprudence of a sort in investment law. So how have things changed? Well, in investment, things mostly haven't changed, right? This area of litigation has expanded, arbitration litigation. It's extremely binding arbitration, so it's kind of quasi-litigation. It's expanded a lot. There's tons more of these disputes, tons more firms in on the game, tons more jobs for enterprising law students to go into this area. So there's not much change other than expansion, although there's always talk about reform, but I haven't seen it happen yet. In trade, there's been big changes.
Yes.
Just turn on the news, right? What's happened to the WTO? The whole thing has, from a dispute resolution perspective, been crippled. The United States in the first Trump administration prevented the apex court of the WTO from having a quorum of members to hear cases. It was called the appellate body. And so now the WTO not only can't hear appeals, but even the first round disputes are kind of called into question because, just to be really technical, whenever you bring a dispute at the WTO, if you lose that dispute in the first instance, you have an appeal as of right. And if there's no one to hear that appeal, the judgment can't be found binding upon you until that appeal is heard, which right now is never. So international trade litigation in the context of the WTO doesn't happen in the same way as it used to. There's still panel disputes, but it's really not the only game in town. However, I would say that there are now more jobs in international trade than any time in my career. because of the chaos in international trade since the first Trump administration, and especially since the second one. Uh, that's just not taking place in international courts and tribunals now. It's taking place in domestic courts like the US Court of International Trade, in the European Union. It's always been taking place in the European Union, but there's more attention to that area from American practitioners. So the place where this stuff happens shifts around. The kinds of topics, now it's much more national security oriented and other kinds of questions. Those things have changed, but the practice is still going strong.
So, why broadly would a country want to enter into an investment treaty when it could have a huge judgment, a huge ICSID judgment rendered against it, if, say, the panel were to find that it expropriated the assets of a private company?
Yeah.
And what are some of the safeguards? And this gets into the exceptions clause kind of dichotomy in your article. What are some of the safeguards that have been set up in the investment regime to kind of allow states to retain some of their sovereignty? And how do we also see that in the trade context?
Yeah. So I'll answer this a little bit backwards, I think. Um, the bottom line in both the trade and investment regimes is these are regimes that states sign up to. States created them, right? They're not foisted upon anybody. Nobody is forced into the investment law regime. It's not like domestic law where you're just subject to legislation. States contract for international legal commitments, and they only do so when they feel the need to make a commitment for some reason. So in both the trade and investment regimes, the idea is to incentivize some kind of economic action. In trade, it's to incentivize trade across borders. We are opening up our markets, which lots of our internal industries don't really want, or sometimes don't want, in order to allow cheaper foreign goods to come in and make the standard of living improve for consumers. Right now, some domestic industries are winners, some domestic industries are losers. When this happens, it's not so obvious where the incentives are. But the point is, it's a commitment by the state to generate trade. In investment, the goal is to generate foreign investment. There is an idea out there with a long pedigree that the best way for states to develop is to get foreign investment in where they can't handle developing certain kinds of resources on their own, or they need foreigners to come in and build IT systems, whatever it is. States don't always have the capacity to develop on their own. That's the theory. And so the question then is how you encourage foreigners to come in and invest. The problem is, the holdup problem that's always identified is that if the state brings foreign investors in, then the state's going to have a temptation to either take the investment without compensating it, or to interfere in various ways when things go south. And the investor, once they're actually in that country, is totally beholden to the state. So investment treaties are about creating very, very binding, highly enforceable, and highly compensable obligations against expropriation without compensation, obligations of fair treatment and non-discrimination. And the idea is if the state knows it's going to have to pay no matter what, then it's a choice between, breach and pay or perform and lose, rather than just a choice to, okay, there's a foreigner here, they've built up a gold mine, and now we can take it for ourselves and extract all the gold and kick the foreigners out. That's great politics, right? That's the theory. So the idea here basically is that both trade and investment are about incentivizing economic action for the purposes of development, for the purposes of raising the standard of living. But it can't be that states give up all of their rights to govern in the interest of these treaties. And because economic life touches upon every other kind of value, environmental values, public health values, national security questions, there's always going to be conflict between the economic disciplines, these commitments, and every other thing the state wants to do, the things we often associate with sovereignty. So, as you would expect, these treaties come with safety valves. And the trade treaty comes with the WTO. I should back up. The General Agreement on Tariffs and Trade, upon which the WTO is based, has an exceptions clause called Article 20 of the GATT that lays out all of these different values that the state is not going to be prevented from pursuing with its regulation, with its tax, with any of its economic instruments. And there's some balancing tests involved. There's a question of whether or not you can, you have to use the least restrictive means available to pursue the value and so on and so forth. But basically, if a state is acting in good faith and doing whatever they can to regulate in the public interest, they should be able to, more or less. That's the theory. Investment treaties typically didn't have any kind of explicit safeguard like that. But it was unimaginable that states would have given up their right to regulate in all these areas. So what happens is you have all these treaties that have a super binding dispute resolution clause, very strong obligations of protection for investors, binding on the state, and they turn out to be extremely enforceable. So something has to give. When the state is saying, we're not just taking this gold mine, we think you're leaching cyanide into the ground, and we're going to stop you from doing that. You're claiming that's expropriation without compensation. We're saying, no, it's a public health measure, right? There has to be some way to resolve that dispute. It can't simply be a strict liability regime. And lo and behold, arbitrators trying to figure out solutions here came up with all sorts of band-aids to fix this, like toying with the standard of review, saying, well, you have to do a proportionality test, or we should afford the state a margin of appreciation, or we should do strict scrutiny or intermediate scrutiny or reasonableness review. They just go down the list of coming up with different ways that different constitutional courts in different countries have tried to resolve this. But the problem is there's no centralized jurisprudential mechanism. So there's no real firm authoritative precedent. There's just different tribunals trying different things. And so some states said, look, we need to resolve this. We need to come up with a more systematic way in the treaties themselves rather than have the arbitrators doing this ad hoc, because it just feels random. It feels like it's post hoc justification. Why don't we just adopt the model that's been working in the trade regime really well all this time, this exceptions clause from Article 20 of the GATT? And so Canada, Australia, while they were still doing investment law, Turkey, and a few other states in their investment treaty practice insisted on clauses basically mirroring the GATT. In fact, in some of these cases, the clause said there will be exceptions that are mutatis mutandis, exactly the same thing as happens in the WTO context, which is kind of a lazy way of doing it and kind of funny. But there are different ways of copy pasting the text, but they all look more or less the same as what's in the trade regime.
And yet it doesn't seem to work. And there's a case, Echo Oro versus Colombia, that you analyze at length in the article, where Colombia is trying to invoke their exceptions clause. And you're basically walking us through in the article all of the factors as to why exceptions clause don't work in the investment law regime, whereas they may have worked for a long time in the WTO regime when that was functional. So why is that? What are the main factors, and where do we see that show up in the case law?
Yeah, so for a long time, basically nobody was really invoking these exceptions clauses. States and their counsel weren't really bringing them up, and so you can't really fault tribunals for not applying them. But at a certain point, once these new treaties started adopting these clauses really explicitly, litigants started invoking them more explicitly. And the thought was that this analysis would go more or less the way that it did in the WTO, and that didn't happen at all. In each one of the cases where the investment clause was, where the exceptions clause in the investment treaty was invoked, it was either ignored by the tribunal ultimately in a couple cases, or applied in a way that devoids it of meaning. It's sort of different technical ways that they got there, but the tribunals basically got to the same place, which was that the exceptions clause might apply, but that's notwithstanding compensation. In other words, it might be that the state didn't do anything wrong, so in a sense they didn't breach anything, but they still owe compensation for the actions that they took that prejudiced the investment of the investor. The theory, I think, behind this is, yeah, you can pursue your public policy, but why should you do it on the back of the investor who's out of business? Why should the investor have to pay? Shouldn't the taxpayer have to pay? It's not a crazy instinct as a policy matter, but it is a crazy interpretation of the exceptions clause, because if there's no breach, how can there be compensation? In international law, you owe compensation as a consequence of a breach of an internationally wrongful act. That's when the duty to compensation emerges. There is no duty to compensate short of that. And so these tribunals maybe had some instinct that was kind of reasonable, but backed themselves into an interpretation of the clause that didn't make any sense. The problem that I go through in the paper, so, okay, put it this way. I think there was a lot of scholarship right away that said this is a matter of arbitrators not understanding the law, arbitrators not having enough background in treaty interpretation, arbitrators worried about losing cases and trying to, make sure that investors still wanted to use this system. So that's a kind of theory of scurrilous arbitrators who are doing something untoward, unethical. And to me, none of those explanations of the failure of the exceptions clause really make much sense. At least in the cases that I saw, it did seem like the tribunals were trying to understand how to work through these issues. I think that they were doing a frankly terrible job of it, but it's not a matter of these particular people having a lack of expertise. And there doesn't seem to be anything too scurrilous going on. In the end of the day, they found no compensation in Echo Oro, the very case that we were talking about. So it's not like they were just giving the win to the investor come hell or high water. They were kind of muddying their way through to a decently workable result. My theory in the article is that the particular type of exceptions clause as a style of justification by which the state can justify its actions in legal terms and therefore expiate the breach makes good sense in the institutional context of the WTO, where you have a centralized dispute resolution system where cases are brought on the basis of a public right of action. Only states can bring cases against other states, and where the remedies involved aren't one-off damages, but are prospective, oriented towards getting the states back into compliance with the regime. Whereas in international investment law, the institutions are quite different. Investors, private actors, have the only right of action. They sue the state, so it's an asymmetric private right of action. There is no centralized jurisprudential mechanism. The cases are heard on a one-off basis by different arbitral panels each time. And finally, the remedies are all retrospective damages, and they're enormous, right? They're damages for the value of the investment as a going concern into the future. To me, the institutional matrices of these two regimes conspire towards making this type of clause work well in the trade regime and work poorly in the investment regime. I'll just give you one of these examples rather than go through all of it. Think about the private right of action versus public right of action. In the context of international trade law, every state knows that they might also get sued for some regulation that undermines a public value. And so they really value the exceptions clause working well. And so you don't see um, as collateral attacks in the when a state is a plaintiff, they don't try to gut exceptions clauses in the interest of winning their case because they know they need that exceptions clause in a future case. By contrast, in investment law, investors are never sued in this regime, and they don't really bring frivolous cases, even though it's often said that they do. Bringing an investment case is a really expensive proposition. You usually do it when you really think you've been wronged and you're not trying to preserve the relationship with the state.
These are usually kind of bet the company cases,
Yeah.
right? Because the amount of resources that you're investing into the case itself is, enough that it will have a serious impact on the company, especially if they lose.
That's exactly right. I mean, bet the company in the sense that not necessarily ExxonMobil betting ExxonMobil, but it's certainly betting the operational company. Yeah,
whatever country they're
exactly.
Yeah.
There's no coming back from it.
Yeah.
And this regime is so high profile, so salient that once you sue a state and win, that state's not going to want you back.
Yeah.
All right. Maybe in some cases they'll have you back, but it's a pretty end of the relationship, bet the company kind of affair. And in that context, the investor has every incentive to do everything they can to recoup every possible aspect of that investment. And that means for them, we should argue that the exceptions clause means nothing, that it's zero, right? And so in that context, of course, the state defends the exceptions clause, but one party's defending it, the other party's attacking it. By contrast, in trade, both parties have a vested interest in making sure the exceptions clause is robust. So that helps to explain partially why there's such a difference in the ultimate results, because the tribunals are hearing very different kinds of arguments. In the trade context, they're hearing a lot of agreement that the exceptions clause is important, and the question is about whether it was applied the right way. In the investment context, they're saying, okay, well, one of you says it means this, the other says it means this. We have to muddy our way through. And I could go through, there's some of the other institutional features have similar kinds of discrepancies that help make sense of the results in one case or the other.
I think maybe taking your argument at face value, the dangerous thing for the kind of global trade regime moving forward is that it actually may start, because of the kind of dissolution of the WTO appellate body and the crisis there, it may start resembling something more akin to, at least in terms of what parties are signatories to subsequent agreements, more ad hoc tribunals in the trade context, more plurilateral and bilateral trade agreements rather than multilateral. So I'm wondering if that will in some ways nullify the kind of positive features of the trade regime that you've seen up to this point in the WTO if it happens that we're in a system where most countries are operating in the trade dispute context with treaties that are creating kind of ad hoc,
Yeah.
tribunals. They're not involving states bringing claims, but private parties bringing claims under trade treaties. Could we see something that's more akin to the investment regime, and therefore kind of brings the same problems with exceptions?
Yeah. So first of all, we're getting into the realm of trying to predict the future,
Yeah,
and
sure.
so all stipulations to the not Nostradamus. But I'll put it this way: I think you're absolutely right to identify that these changes are going to put pressure on the trade regime, and the kind of pressure that we've seen in the investment context. But at least of the institutional features that I've been talking about, who has the right of action, what are the remedies involved, and how centralized is the system of jurisprudence, it's really only the last one that is buckled with the appellate body crumbling. That means dispute resolution in the WTO is not happening, but we have these mega regional trade treaties like the CPTPP. We have, well, for now, we have the NAFTA, USMCA. Give it time. I'm not sure we'll have that for that much longer, but you have lots of these types of big regional treaties, and there are also bilateral trade agreements. And in all of those, there's dispute resolution clauses. A lot of them say in the dispute resolution section that tribunals should pay attention to the jurisprudence of the WTO and the appellate body. Um, and a lot of their rules are kind of copy pasted from the WTO context. And so I actually think, not because the tribunals have to, but because for so long, trade arbitrators were trained in the jurisprudence of the WTO, that I think there's going to be a really long shadow from the appellate body's jurisprudence. So, at least for a time, the kinds of precedents that we've all in trade law classes been learning as the doctrine of trade law, they're going to continue to have a lot of effect. But give it long enough, there will be some splintering, for sure. That said, the idea of how the exceptions clause, at least that particular thing, works is so firmly ingrained in that WTO jurisprudence that I would be shocked if it was, completely abandoned. Similarly, with the non-discrimination norm or the MFN norm, right? Those, as they're interpreted by regional treaties, even though treaty tribunals, even though there's not formal precedent and an appellate body and all that kind of thing, I think it'll look fairly similar for a while. Beyond that, though, the other institutional features are still there, right? There's no capacity for anyone but a state to sue another state under regional trade treaties, with the possible exception of some very bespoke labor provisions, which are pretty rare. It's still state to state for the most part. So all of those concerns about the glass house dynamic, where no state wants to antagonize the exceptions clause because they're worried they might need it in the future, that still applies. Trade treaty remedies are still not going to be retrospective damages. They're still prospective. And so those different kinds of features still distinguish this system very strongly from the investment treaty regime. But 20 years from now, we could have a completely different interface in all of this. The one thing you're absolutely right about is the more fragmented the trade regime gets, the more problems are going to start to crop up in the genre of the sort of free-for-all Wild West of investment treaty law.
So I want to move back to investment law for one more question and then wrap up. So if I'm, say, a leader of a developing country who's on the more progressive side, I'm really kind of concerned about protecting my country from foreign investment that's kind of extractive in nature, but I also recognize that it may be necessary along the path to development, foreign investment, both for my own kind of political fortune and also for the long term
Sure.
growth of my country. How do I adequately protect my sovereignty while encouraging investment that doesn't have some of the pitfalls of the exceptions clause? I look to the exceptions clause and I say this is going to be inadequate for me to actually protect myself if a claim gets brought against me for all of the factors that you laid out. What are the ways in which I can protect myself?
Yeah. So I think you have to imagine two different worlds. I think it's a really important question that policymakers in every developing country think about all the time. And you have to imagine two different worlds. There's a world in which we think we need to have investment treaties and we need to then discipline them, right? We need to moderate what they do. which is, I think, the world you were presuming in the question. And the other world is the no investment treaty world.
Yeah.
So in world one, what I'm saying is if you have investment treaties, the band-aid of copy pasting something that's worked very well in the WTO context and hoping it will work here is a false friend. It's a false illusion because the institutional regime isn't set up to give this clause the kind of meaning that it had in the WTO. And so what's left? What can you do? Well, there's a lot of different ideas out there. To me, almost all of them suffer from the same kinds of weaknesses. Like, for example, you might say we're excluding climate measures from the ambit of this treaty. The problem is, how do you decide what's a climate measure? The state's going to say it's a climate measure. Well, maybe they say we found an endangered species and we think that's a climate measure. Is that a climate measure? Migration could be a climate measure, right? And there are good faith expansions of the concept of a climate measure. So anytime you create an exclusion rather than an exception, there's a risk that the state will try to use that to cheat, right? Even if they're not. And so the problem of the tribunal having to decide all of this doesn't really go away. To me, the only way to moderate the vigor of this regime, there are really two or three promising ways. The first and most important one is to reduce the scope and power of the primary rules themselves, the disciplines. The core discipline of investment treaties is thought to be the discipline of expropriation, which is takings, right? You have a factory, the state takes your factory, and they don't give you any compensation. It turns out that investment treaty jurisprudence, the expropriation law, works pretty well. Most of the concerns with the regime aren't really about expropriation cases because it's a high bar to prove an expropriation, even indirect regulatory takings. What doesn't work as well, or at least the critics of the regime say, like myself, where the regime goes too far, is a separate clause called fair and equitable treatment, which, because the expropriation is so hard to make out, investors have successfully gotten tribunals to adopt a very, very capacious notion of fairness and fair treatment that covers everything from discrimination, arbitrariness, a lack of transparency, a lack of consistency in government measures, and makes all of those maximally compensable as if there had been an expropriation. And so I think disciplining that or just removing that clause from the treaties would go a long way. There's a very good reason to have protections against expropriation if you want to attract foreign investment, right? I mean, it can't be right that you attract foreign investment and then you just take the investor's stuff whenever
Right.
you want to. That's nonsense. So expropriation's, I think, a pretty good, you know, pretty good place to leave it. Um, Maybe add non-discrimination, right? It depends on how you set this kind of thing up. But I think the most successful thing you can do is take down those primary rules. The other thing you can do is try to moderate damages. It's a fashionable approach in the literature right now to say we need to get damages under control. I'm not sure that's that easy to do because if you have a damages-based regime, of course you have to be able to project future earnings, and it's not so simple as saying you shouldn't be allowed to use one type of calculation versus another. These are long-standing problems in domestic law. Maybe there's a way to limit damages in some way, but I haven't seen one that makes a ton of sense in the sense that I shouldn't say that. It makes sense intellectually, but I don't have faith that tribunals will be able to apply those limits in a sensible way. So to me, the most important area to reduce the worst parts of the excesses of the investment regime are just reducing the primary rules themselves and trying to institute maybe some kinds of safeguards into the damages context. The one really big exception is that tribunals need to pay much more attention to how the actual investment itself is structured. And there are cases where the investment is structured through a contract that has things like a liquidated damages clause.
Mhm.
You have to give effect to those. You can't just ignore those and do international law damages. And if you're giving effect to those, then a state subject to an investment treaty can protect itself by forcing investors to contract to a more limited damages provision. And then the investor and the state can just decide whether the risk allocation is worth it to them in that context. So that's one universe. The other universe is the no investment treaty universe. And there's not much to say about this except that I think it's often, there are two assumptions that are often made about this regime that need to be challenged. The first is that FDI is good. And the second is that in order to get FDI, you need these treaties. Neither of those things are so obvious, at least in a pure, simple sense. There's good foreign direct investment, there's bad foreign direct
Right.
investment. Not all of it is stuff that you want, and it's not clear what a treaty regime like the investment treaty regime is incentivizing, right? Secondly, it's not entirely clear, or it's not at all clear, that you need an investment treaty regime to incentivize foreign direct investment at all. Look at Brazil. Brazil does not have international investment treaties. There's plenty of foreign investment in Brazil. Now, maybe that's because it's such an important market that it's able to leverage that, and a smaller market, Somaliland or something like that, might not really have that
A
kind of
lot of natural
flexibility.
resources there too, right? It's
Yeah,
like it's not a place where you necessarily need to become a tax haven to attract people.
exactly,
Yeah.
exactly. And all the risks are still there. If there's natural resources, if there's oil in Brazil, a foreign investor wants a piece of that oil, they're still subject to risk
Right.
of expropriation and things like that. But they govern those risks through their contracts. And if you're Brazil, you're hypothetical. If you're Brazil, you have a lot of market power to demand a contract that will protect yourself. Where I worry a lot more, and I just don't know how it cuts, is a relatively small, weak state that doesn't have the power to contract in a way that's going to benefit it or protect it, or maybe even the capacity to put the right kinds of things in the contract. And then, in a kind of perverse way, maybe a standard cookie cutter form investment treaty might actually be a better balance for that state than trying to do everything through the contract. And if that's the case, then maybe the answer is, you know, you're stuck with it. I'm really not sure though, and I think that's a sort of unfortunate conclusion, given how excessive the jurisprudence often has tended to be in the investment treaty context. But one needs to really think creatively, and states that don't have a ton of capacity are looking for models. So the last thing I'll say is there are some states that have been trying to create new models for the world. For example, South Africa has been trying to generate new model treaties that are more solicitous of the state's interest. And this is a really useful way to go because it's a state of the global south trying to entrepreneur new models that other states who lack the same kind of capacity might be able to adopt on their own. Will those models work? They haven't been really adequately tested yet. Maybe, maybe not. But your choices are either go the Brazil route and maybe forego FDI, or be beholden to contractual negotiations where you don't have the kind of power that Brazil has, or follow models based on something like what South Africa is doing and hope for the best. It's not a super hopeful story, though.
Yeah. So, two questions to wrap up that we do with all of our
Sure.
authors. So, the first one is if you could recommend any piece of media about international law, whether it be uh, a treaty or even a movie or TV show, what would it be?
If you want to understand international investment arbitration, I think the single greatest, though quite critical, uh, piece of media for just getting a sense of the power of this regime is John Oliver's segment on tobacco. Just go up, look up online John Oliver segment on tobacco. Surprisingly, the whole thing is about international investment disputes,
Yeah.
and it is just a perfect capsule of what this regime can do and the almost ridiculous nature of its excesses. The regime probably has gotten a little bit better since then, but it tells you everything you need to know.
I didn't know that the tobacco piece was all about international investment arbitration.
It's about Philip Morris's attempt to sue Uruguay and its letters of intent to sue Togo and other countries
Oh,
for adopting plain packaging legislation,
wow.
which it said was a regulatory taking of its brands.
But somehow tobacco seems to arise again and again in the trade and investment context.
Yeah.
It's always there. Final question is if you had any piece of advice for a law student who's seeking to write a sharp piece of legal scholarship and get it published, what would it be?
Yeah. So the best thing that you can do if you want to write legal scholarship and as you're thinking about your first piece, the most important thing is to try to strike a balance between keeping things adequately narrow and writing about things that matter. You can't go in and write a new theory of international law, right? I mean, that takes years upon years of experience, and most of the time, theories of international law aren't that good anyway.
Yeah.
You also don't want to write about something so utterly narrow that it doesn't really matter, that nobody cares about it. And so, my advice is to ask yourself what draws you to writing and draws you to scholarship. What is it that bothers you? When you read books about international law, or if you don't read books about it, when you read articles or whatever it is, or just talk to people in the field, what bothers you? What kind of niggles in the back of your brain as saying, something's wrong here? Think about that. Think about why that thing matters, and then try to find a way of getting purchase on that issue through something narrow. So it's like the theory of the acorn and the oak tree, right? You want to write about the acorn in a way that makes clear what the oak tree is going to look like. You write about how there's some perverse interpretation of some particular legal rule that seems narrow but implicates all of these important global issues. And you want to do it explicitly, right? So that's how you pivot. You sort of focus the hard intellectual labor on researching and writing about something relatively narrow, but which gets at some broader issues that bother you personally and make you wake up in the morning and want to keep writing. So it's not an easy task, but it's something that is impossibly difficult if you just wake up and decide, I'm going to write about something really important. The way it works is if you read books, you read articles, you read the news, and the things that are of the moment important are going to start to jump out at you, and then you chase those down. But you drill down and draw the big thing out of the mixed metaphor that I just described.
Great. Well, Professor Julian Arato, thanks so much for joining the MJIL podcast. It was a pleasure, and thank you for listening to all of you out there.
My pleasure. Thanks, everyone.
All right.